Hello again. I'm Aaron Goth here. I'm judge of the 53rd Circuit Court for Sheboygan and Presque Isle counties in beautiful northern Michigan. This is another installment in our Ask the Judge video series, and this is on plea bargains part 2. We're going to cover sentence agreements and recommendations. I did a video on plea bargains before. You can check it out in the playlist of Ask the Judge on the history of plea bargaining in America, how they're used, what the benefits are, and the costs are to a plea bargaining in the criminal justice system. In this video, I'll explain something that you'll sometimes see if you watch plea hearings in my court: sentence agreements and sentence recommendations. Sometimes we refer to these by the shorthand of Killebrew and Cobbs in Michigan. Now, as a background, most plea bargaining is what is called charge bargaining. And this is where the prosecutor agrees to dismiss some charges or the principal charge in exchange for a plea to less charges or to a reduced charge. So they're bargaining about the charges, charge bargaining. This is entirely in the control of the prosecuting attorney. They have the constitutional authority to decide who to charge, what crimes to charge them with, which cases to dismiss outright, and what reduced charges to offer to defendants. The judge generally has no control over this process, with some very limited exceptions that are not relevant to our discussion today. Now, as plea bargaining became more commonplace, a new form arose, so-called sentence bargaining, in which the prosecutor where the prosecutor would agree to recommend a specific sentence in exchange for a guilty plea. Of course, this would be a more lenient sentence than what might be expected absent the agreement. Now, this raised all sorts of concerns in the criminal justice system because although the prosecutor has the authority over what crimes to charge, the judge has the authority to decide what the appropriate sentence is, of course, within the parameters of the law. So in a 1983 case called People v. Killebrew, the Michigan Supreme Court recognized the legality of prosecutor agreements and recommendations about sentencing as part of the plea bargaining process. But the court had some concerns to address. They didn't want to limit the judge's sentencing authority and discretion, and they didn't want to coerce involuntary pleas, and they didn't want to interfere with the judge's neutral role in the criminal justice process. So the court in Killebrew allowed sentence recommendations and agreements, but they held that those agreements do not limit the authority or discretion of the sentencing court. In other words, they're not binding on the judge. But if the judge chooses not to follow that agreement or that recommendation, the judge must allow the defendant to withdraw the plea. And before asking the defendant to make that choice, the judge should first announce what sentence would be imposed if the plea is affirmed. As to the other concerns, in order to prevent judges from coercing pleas and to preserve the neutrality of the judges, the Supreme Court said that judges should avoid participating in the plea bargaining process, the plea negotiating process. That's between the prosecutor and the defense attorney. 10 years later, in a case called People v. Cobbs, the Supreme Court expanded on the judge's role a little bit. In that case, they said that the judge, at the request of either the prosecutor or the defendant, or both, may give a preliminary evaluation of what sentence the judge would impose for a crime charged, or if there's a plea offer for the reduced charges. Then, similar to that Killebrew process, if the judge does not follow the preliminary examination or the preliminary evaluation at sentencing, say because the judge got some new information from the pre-sentence report or some information that caused them to change their mind, then the defendant must first be allowed to withdraw their plea. But different from the Killebrew process, the Supreme Court said that the trial court should not first announce what their sentence would be. The reasoning was that since the initial evaluation came from the judge, the Supreme Court thought it would involve the judge a little bit too much in the plea bargaining process to give a preliminary evaluation, not follow it, and say, but here's what I would do instead. They felt that was a little too far. Now, that's a lot of theory and history. Now, let me give you the bottom line of how this works in practice today in Michigan courts. These cases have since been incorporated into the Michigan Rules of Court, or Michigan Court Rules. These are adopted by the Supreme Court, and they govern procedure in all Michigan state courts. For those interested, go ahead and check out MCR 6.302C and 6.310B2. Now, there are three types of sentence bargains in our modern courts in Michigan. First, sentence agreements. The prosecutor and defendant can reach a sentence agreement that limits the sentence in different ways. For example, the agreement can be for a sentence to a specific term, like an agreement that the minimum sentence will be 18 months in prison, or an agreement that the sentence will be zero jail, no upfront jail. Or the sentence can be for, the agreement can be for a sentence within a specified range. For example, they can agree to a guideline range of 5 to 23 months, or they can agree to a county jail cap. You'll hear it, a county cap. And that means no more than 12 months in the county jail as opposed to a longer prison term. Or a sentence agreement could be that the judge will not exceed the advisory sentencing guidelines range. Now, I'll do a separate video later on the sentencing guidelines, which is a rather complicated subject, a large topic on its own. Now, the sentence agreement can also be for what's called a deferred sentence of some sort. And I'll do a separate video later on the types of deferred sentences. You hear these if you watch our plea hearings or sentences for youthful offenders or first-time drug offenders or some things like this, or a delay of sentence. And a sentence agreement can be for that sort of deferral. Or the agreement could be for concurrent sentencing instead of consecutive sentencing. And you can check out my video on sentencing part 2, where I talk at the end about concurrent and consecutive sentencing in Michigan. So all those different things can be part of a sentence agreement between the prosecutor and the defendant. Judges don't have to allow these types of agreements at all. They are not mandatory on courts. And some judges throughout our state do not allow them. Even in our county, the judges have different approaches on this topic. And there's no right or wrong answer here. It's a matter of personal philosophy and approach. For courts that do allow sentencing agreements, if the judge knows right away that the agreement is just not going to fly, the judge doesn't have to accept the plea. And you'll see me sometimes do this in our courtroom. But more commonly, the judge will accept the plea with the sentence agreement and then await more information from the pre-sentence investigation report. And then at sentencing, the judge doesn't have to follow the agreement. But if not, the judge must first tell the defendant what sentence the judge intends to impose instead of the agreement, and then give the defendant the option either to withdraw the plea or to affirm it and go forward with the sentencing. And if you watch enough hearings on our YouTube channel, you'll see me do that. Now, there's an exception to that. If the defendant has engaged in misconduct between the plea and the sentencing, like absconding on their bond or failing to appear for court, violating bond conditions, or committing a new crime. In that case, the defendant, by their misconduct, has forfeited the right to withdraw the plea, even if the judge does not follow the sentence agreement. All of this must be explained to the defendant before they enter their plea in the first place. So if you watch enough plea hearings in my court, you'll see me go through this fairly complicated advice process with every defendant who's relying on a sentence agreement. And because this process in the court rule so closely models the 1983 Supreme Court case, judges will sometimes refer to this by the shorthand of that case name. And they'll refer to this as a Killebrew plea or a Killebrew agreement. So that's the first type. The second type is a sentence recommendation. And this is where the prosecutor can induce a defendant to plead guilty by promising to make a sentencing recommendation to the judge. Now, this can't be a secret agreement off the record. It has to be made part of the plea agreement up front and placed on the record. That's why you'll see me, when people enter a plea, ask the defendant and both lawyers whether there are any other promises, threats, or inducements to lead to the plea, because we don't want any off the books promises. Now, these recommendations can encompass all the options that I mentioned for sentence agreements, like specific terms, specific guideline ranges, etc. A sentence agreement can also include other factors, such as participation in certain programming in or out of the jail, allowing a defendant to serve their jail in a county where they live, or limiting the length of the term or the terms of a probationary order. As with sentence agreements, a sentence recommendation is not binding on the judge. At sentencing, the judge doesn't have to follow the prosecutor's recommendation. But the difference between an agreement, a sentence agreement, and a sentence recommendation is that for a sentence recommendation, the judge does not have to let the defendant withdraw their plea if the court's not following the agreement. This important distinction is why you'll sometimes hear me clarify on the record whether the plea involves a sentence agreement or a sentence recommendation. It's a big difference. With the agreement, you can withdraw your plea if I don't follow it. With the recommendation, you can't. Now, you might think, well, then the defendant's not really getting anything in exchange for the plea, but that's not quite right. The sentencing judge takes a prosecutor's recommended sentencing very seriously into consideration at sentencing. So it's not nothing, it's not binding, but it certainly carries a lot of weight. Now, even though the Killebrew case mentioned sentence recommendations, the process in the court rules does not allow the defendant to withdraw their guilty plea anymore for not following a recommendation only. So when courts today refer to a Killebrew plea, they're likely referring to a sentence agreement and not to merely a sentence recommendation. But you'll see these sometimes if a prosecutor doesn't want to lock something in, but they just want to make that recommendation. The third option that you'll hear is called a sentencing evaluation. And this is where the court can give a preliminary evaluation that it will sentence a defendant to a specific term or within a specific range or some other thing, like give a deferred sentence. But before sentencing, the court will receive a detailed pre-sentence investigation report, and we'll hear from the parties, sometimes get letters of support from the community for a defendant, or hear from the victims of the crime. You'll see this at sentencing when you watch sentencing. So when the court gets that new information, the court might think, well, I can't follow my own preliminary evaluation of the sentence. So in that case, the court must first give the defendant the opportunity to affirm or withdraw the plea. But different from the Killebrew situation, the court may not state the sentence it intends to impose. This again is to avoid getting the judge too involved in the plea negotiating process. And just like in a sentencing agreement, a defendant's post-plea misconduct can forfeit the right to withdraw the plea. Since this process closely follows that outlined in the Cobbs case, courts sometimes refer to this still as a Cobbs plea. And just as with the sentence agreements, courts are not required to take pleas with Cobbs evaluations or provide a Cobbs evaluation. Many judges do so, but many do not. My own practice in both counties in my circuit is that I allow Killebrew sentence agreements and I allow sentence recommendations, but I do not offer Cobbs evaluations. Now, my reasoning is that I just don't know enough about the case before I get the full pre-sentence investigation report for me to feel comfortable with that Cobbs process. But I do allow the parties to engage in sentence agreements because they know the cases very well. They have the police reports. They have talked to witnesses and victims. And sometimes it surprises people. The judge knows very little about the case until there's a plea or a verdict, or sometimes things come out during motions. But judges don't read the police reports. That'd be improper while the case is still open. Or judges don't go out and talk to witnesses or victims. I mean, that would not be proper at all. So I just don't know enough about the case for me to make an evaluation that I have any confidence in. But the parties know enough about the case that I have some confidence that it might be at least reasonable to go down that road. And I know that once I learn more through the pre-sentence report, if I disagree with their assessment, I don't have to follow their agreement anyway, as long as I let the defendant withdraw the plea. So there's really no harm in letting that go forward, unless, as I said earlier, it's just clear to me from the beginning, given my sentencing philosophy, there's just not a chance that that agreement is going to fly. So then I try not to let people get their hopes up falsely. So to wrap that up, there's three basic situations we've described. First, a Killebrew sentencing agreement that's not binding on the court, and the defendant can withdraw their plea if it's not followed, absent misconduct. Second, a sentence recommendation. Again, it's not binding on the court, but there's no right to withdraw the plea if it's not followed. And finally, a Cobbs sentence evaluation. Although the court made the evaluation, it's not binding on the court if the court receives some new information to change its mind. And there again, the defendant may withdraw the plea if it's not followed, absent some misconduct. Now, there's one other wrinkle. What if at the sentencing, the judge wants to give a sentence more lenient than what was in the sentence agreement? Surely the defendant's not going to object to that. The prosecutor might not like it though. And the prosecutor reduced the charges in reliance on that sentence agreement. So if the judge is going to go below the sentence agreement, the prosecutor has to be given the right to cancel the plea agreement. And then the defendant's plea is withdrawn, whether they want it or not. And it goes back to a pretrial standing. So that's just a summary of one aspect of plea bargaining. As you watch plea hearings, listen for whether there's a sentence agreement or a sentence recommendation. You're not likely to see a Cobbs evaluation if you're watching me, but you might see that in other courts. And ask yourself what you think of that agreement, whether you would follow it or not. And then tune back in for the sentencing hearing to see whether the agreement is followed. And please remember to subscribe to the channel, enable notifications so you know when we're going live for court or when we're posting a video like this explaining the process. And as always, I'll see you in court.